Imagine building a house brick by brick for 6 months. You got the permits. You followed every rule. Thousands of people moved in. And then, one morning, a judge knocks on the door and says, the house doesn't exist anymore. That is exactly what happened to Nigeria's NDC last Friday. We are asking the question every Nigerian needs to hear. Is our democracy being dismantled before a single vote is cast in 2027? On Friday, June 26, 2026, Justice Isaac Dashin of the Federal High Court, sitting in Lokoja, Kogi State, did something that legal scholars are calling extraordinary. He set aside his own judgment 6 months earlier, on December 10, 2025. The same Justice Dashin had ordered INEC to register the Nigeria Democratic Congress, the NDC, as a political party. INEC obeyed. The NDC was registered. The party went to work. It held ward congresses, state congresses, and national convention. It conducted primary elections, monitored by INEC. It produced a presidential candidate, Peter Obi, and a running mate, Rabiu Musa Kwankwaso. Both names are on INEC's portal. Then on June 26th, 6 months later, Justice Dashin wiped it all away. His reason? A little-known association called the Peace Movement Party. The PMP filed an application claiming it was not heard in the original December 2025 case, and that the NDC's logo, the two-finger victory symbol, actually belonged to them because they had submitted it to INEC 2 years earlier, back in 2015. The judge agreed. He set aside his December ruling. He ordered the case to start again from scratch, this time with PMP included as a party. The practical effect. As of today, there is no valid court order compelling INEC to recognize the NDC. The party's legal existence is once again hanging by a thread. Now, here is where it gets really uncomfortable for Justice Dashin, because the legal community is not staying quiet. There is a principle in law called functus officio. It is Latin, and it means simply, once a judge has delivered a final judgment, his duty on that case is done. He cannot go back. He cannot reopen it. He cannot change his mind 6 months later because someone new knocked on his door. There are only two exceptions: if the original judgment was obtained by fraud, or if it was void from the beginning. Justice Dashin himself acknowledged this principle in his ruling, but he bypassed it, citing the constitutional right to fair hearing for the PMP. Legal analysts have pointed out several problems with that reasoning. First, PMP never challenged INEC's own refusal to register them as a party. If their logo was so important, why didn't they go to court themselves? Second, PMP did not seek to join NDC's original case, even though they knew about it. Third, when PMP finally filed their application to set aside the December ruling, it was 5 months after the judgment. They even had to ask the court to extend the time for their application, an admission that they had not acted quickly. In law, equity aids the vigilant, not those who wait in the shadows and act only when a party becomes politically relevant. And that last point is the one that political observers cannot get past. The NDC was a quiet party. Almost nobody noticed it until Peter Obi and Rabiu Kwankwaso joined, until that convention in Abuja, until the party zoned its presidential ticket to the south and started looking like a real national force. That is precisely when PMP suddenly found its voice. That is when the legal challenges multiplied. And that, for many Nigerians, is not a coincidence. The NDC crisis does not exist in isolation, and that is what makes this story so serious. At the same time, the NDC was fighting for its legal life in Lokoja. The African Democratic Congress, the ADC, was battling a separate federal high court judgment in Abuja ordering INEC to deregister it entirely. The Court of Appeal later issued a stay of execution, pausing that deregistration order. But ADC is not out of danger. And this week, former Vice President Atiku Abubakar, the ADC's presidential candidate, publicly alleged a fresh plot to keep his party off the 2027 ballot. Let that register. The two main opposition parties in Nigeria, both of them are simultaneously fighting court battles threatening their very existence. One of them has the candidate who scored 7 million votes in 2023. The other has a candidate who scored 6 million votes. Together, they represent 13 million Nigerians who chose them in 2023 and would choose again in 2027. If both parties are knocked off the ballot by court orders before a single voter casts a vote, what kind of election is Nigeria holding in 2027? Atiku's aide described the situation bluntly as a plan to create a de facto one-party state. Seriake Dixon, the NDC's national leader, called the Lokoja ruling illegal, anti-democratic, and aimed at stifling the opposition. The Obi Kwankwaso movement's national coordinator said, simply, "We saw it coming." Despite the ruling, the NDC is not lying down. The party has filed an appeal at the Court of Appeal and simultaneously filed an application for a stay of execution, meaning it is asking the appellate court to pause the effect of the Lokoja ruling while the appeal is heard. INEC has said it is awaiting the certified true copy of the judgment before taking any action. And as of Monday night, Seriake Dixon confirmed that Peter Obi's name remains on INEC's portal, meaning the party is still, for now, operational. Dixon, speaking on Channels Television, dismissed reports of candidates abandoning the party. He called the court situation a kangaroo attempt to unsettle NDC and appealed directly to all party candidates to hold firm. Kwankwaso echoed that call, urging members to stay calm, stay focused, and trust the legal process. The ball, as Dixon put it, is now in the Court of Appeal's hands.